Hello, everyone, and welcome to another live edition of Employment Law Q&A. Welcome all. My name is Alex Lucifero. I am an employment lawyer and disability insurance lawyer at Samfiru Tumarkin, LLP. We are the employment lawyers in the country. This is a live Q&A. We are here to answer any and all questions that are related to your workplace rights. If you are dealing with a situation at work right now and you're just tuning in, well, guess what? You're listening to and speaking with an employment lawyer and partner with the firm. This is your opportunity to get your employment questions answered. If you're dealing with a situation at work, maybe your boss is giving you a hard time, maybe you've been let go from your job, maybe you've been laid off from your job, or maybe you're just dealing with a difficult colleague, or you feel like you might be being mistreated in the workplace. This is your opportunity to get those questions asked and answered. I cannot answer any family law questions or criminal law questions, but I guarantee you, if you have a question about your work and your rights at work as an employee, this is the time, this is the place. Of course, we do these live streams on a very regular basis, almost every day. So if you've tuned in before, you know the drill. We are here to help. We are here to point you in the right direction when it comes to your workplace rights and answer any and all questions. That applies as well, by the way, to any questions or issues you might be having when it comes to a medical leave of absence. If you are ill or you're dealing with a medical issue or an injury at work and you've had to take some time off, and maybe you've applied for disability insurance through your benefits provider, and you're getting difficult responses, or if you've been rejected perhaps or declined insurance benefits, well, guess what? We can help you with that situation as well. Any questions with respect to medical leaves, any questions with respect to disability insurance, we are here to answer as well. As usual, I like to start off the show by sharing our contact information. So if you're perhaps a little too shy, a little too bashful to get your questions answered online, that's okay. You can always reach out to us privately and confidentially, whether you want to email us or give us a call or visit our website. Please go ahead and contact us whichever way you like. I'll start with the email address that you can reach us at. And please, by all means, feel free to send us an email. There's no commitment, there's no cost. Email us at help@employmentlawyer.ca. It's on your screen right now. Don't send us a 20-page email. Please do us that favor, but send us a couple of paragraphs on what kind of situation you're dealing with. Give us a brief description of your situation. I promise someone will get back to you with that issue. You can also visit our website, of course, employmentlawyer.ca. www.employmentlawyer.ca is the website. We have a ton of resources online. We have articles, video clips. We have essential guidelines as to kind of the basic employment issues that most employees will deal with over the course of their career. Really just a ton of resources that you can use as a starting point to figure out, okay, well, what might my situation be? And of course, we've got all of our contact information there as well on our website, our individual lawyers and throughout our various offices in Canada, whether that's British Columbia, Alberta, or Ontario. Certainly go ahead and give us a call and visit the website. All right, let's start the segment with, well, it's something we call the case of the day. This is typically something we do on the radio show that we host every night in Ontario, at least. And it's an opportunity to talk about a matter that came across my desk, and I think a learning opportunity for employees out there. Now, as I'm going through the case of the day, and I think this will be valuable information for a lot of our viewers and listeners, I do want you to start posting your questions. So for those of you tuning in, again, don't be shy, don't be bashful. Go ahead and post your question right now on whichever platform you're viewing on, and I promise I will get to your question. For example, Kevin on Facebook, I see you already. I will absolutely get to your question. But again, for those others of you, it could be a generic question. You could just be curious about something. Maybe you want to know what severance entitlements you might be owed if you're ever let go. Give me your age, position, and years of service, and I'll be able to tell you what your severance entitlements are. or again, any random issue that you might be dealing with at work, go ahead and post that question. And I promise I will get to it before today's live show is over. But case of the day, and this is something that quite frankly is happening lots nowadays. We're seeing more and more companies restructure their operations, downsize their businesses. Unfortunately, we saw this at the end of last year, and we're certainly seeing it at the beginning of this year. We're seeing lots of employers make changes to their workplaces, to their departments. And unfortunately, what that means is employees are being let go from their jobs and being offered severance packages. Now, we say this all the time on our various platforms and shows. It is unfortunately the case that employers, when they are letting employees go, the severance offers that they make them are almost always, if not always, going to be far less than what an employee's actual severance entitlements are. Case in point, spoke to an individual this morning who was let go from his job. He was a very nice fellow in his early 40s, had about 7 years of service with this employer. And for one reason or another, nothing to do with his performance or his conduct. He was a very good employee, good performance reviews, no previous issues. He was let go from his job. Now, unfortunately, he was only offered a minimal amount of severance. He was actually only offered 8 weeks of severance, so just slightly more than 1 week per year of service as a 7-year employee. And rightfully so, he reached out to us. He wanted to know, what are his severance entitlements? What is he actually owed? Is this a fair offer that the company has made him, or is this not a fair offer? Now, the way in which severance is calculated, and our longtime listeners will know this very, very well, but for those of you perhaps just tuning in, or those of you who don't maybe know the way severance works, in Ontario at least, and this is generally true across Canada as well, severance is based on an employee's age, position, and years of service. The older you are, the more senior your position is with the company, the longer you've been with that company, the more severance you are going to be owed. And so in this gentleman's case, again, he's in early 40s, I believe he's 42 if I remember correctly, had been with the company for 7 years, and he was in a supervisory position. It was a kind of technical supervisory position in IT, essentially. And so he wanted to know, what are his severance entitlements based on his age, position, and years of service? Now, keep in mind, the company offered him 8 weeks of severance. His severance entitlements, this individual's severance entitlements based on his age in his early 40s, 7 years of service, and supervisory position, his severance entitlements could be as much as 8 months of pay, not 8 weeks, to be clear, 8 months of pay. That is a huge difference, very obviously, in his actual severance entitlements as compared to what he was actually offered. I wanted to touch on this subject today, because I had just spoken to this individual this morning. So it is a very, very recent, very live issue. We're going to be assisting him, of course, in obtaining his proper severance entitlements. But I also wanted to share it because, unfortunately, this is not an atypical story. We see this kind of situation where the delta, the difference between what an employee is offered and what they're actually owed is very significant. We see it every single day. It is unfortunately the case that an employer will try and pay as little as possible, as minimal as possible, really, to an employee once they're let go. And it's not because they're the worst employer in the world. It's not because they're overly cynical or, want to punish this employee. The employer, as a business, as a company, is looking out for its bottom line. It is looking for the best deal possible in this transaction. And from the employer's point of view, it is a transaction. It's business, right? They're looking to pay as little as possible. They're looking for the best deal possible. It's extremely important to remember, as an employee, your thought process should be the same. You have to look out for your own best interests, and you have to, from the other point of view, try and maximize your severance entitlements and what you can get out of the employer as a result of a termination. Again, not in a cynical way, not in an unreasonable way, but because as an employee who's been let go, you have to make sure that your short-term financial future is secure. You have to make sure that you have enough financial compensation to allow you the time that you need in order to go out there and find that next job. And not just any job, by the way. You should be looking for a job that is comparable in terms of pay, in terms of position, etc. So as an employee who's been let go, sure, you should be looking for work, but you have every right to look for something comparable to what you left, to what you've been let go from. And that oftentimes will take some time. It's very difficult to bounce back into a job very quickly, especially a job that's comparable in terms of your previous pay and whatnot, especially if you've been with that company for a long time. So we are going to be assisting this gentleman in getting him his proper severance entitlements. There is no question that he is owed significantly more than what the company has offered. And again, his severance entitlements are likely 8 months of pay based on his 7 years of service and supervisory position. That's not, by the way, a controversial number or a shocking number, right? This is employment law 101 stuff. Severance is not a complicated subject. And most employment lawyers and employers, for that matter, themselves would agree, right? But it is about the dynamics of that situation where, unfortunately, most employers are looking to pay as little as possible. As an employee, you want to make sure that you're getting a fair offer, a reasonable offer. And oftentimes, the first step down that road is making sure that you speak with an employment lawyer if you've been let go from your job. Do not, and this should be obvious advice, of course, to all, make sure that if you're sat down for a termination meeting and you're being let go, of course, that's an upsetting situation. Of course, the emotions are going to be running high. The stress is going to be running high. Do yourself a favor. Do not make any rash decisions. Do not sign anything on the spot. Stay cool, stay professional. You shake your employer's hand. You walk out of that meeting, right? And give us a call as quickly as possible. In many situations, in most situations, actually, we will offer free consultations to review an employee's severance package. And we will tell you the honest truth about what your severance entitlements are, good, bad, or ugly. And if you need assistance and need guidance in a severance negotiation, that is exactly what we are here for. It is the bread and butter of our work. It's what we do all day, every day, and we do it pretty darn well, if I can say so myself. So again, if you're dealing with a situation where you've been let go from your job, fortunately, we're seeing it lots nowadays. Give us a call. Make sure your offer is fair, right? And if the offer is fair, we will tell you so and get moving on to new employment, hopefully sooner rather than later. But that is obviously an extremely, extremely important and difficult situation where you need professional advice from an employment lawyer. All right, and with the case of the day out of the way, and thank you all for your patience, we are going to get to the good stuff. We're going to get to the questions. Before that, very quickly, just want, for those of you just tuning in, just as a little reminder here, and a welcome. My name's Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP, partner with the firm as well, and this is a live Q&A session. If you're just tuning in, and you have a query, you're curious about a situation at work, you're curious about whether your employer can do something or not, or perhaps you're being mistreated at work, or you feel you're being mistreated, you want to know what options you have, go ahead and post your question right now. We're going to be live for the next 15 minutes, and I promise I will get to your question in that time. So go ahead and tune in. And if you don't want to post your question right now, certainly feel free to email us or visit our website. Email address is help@employmentlawyer.ca. Very simple email address, help@employmentlawyer.ca. Website is employmentlawyer.ca. And go ahead and visit us there if you want to peruse our website and get some more information about us. All right. First in line, Kevin, thank you for your patience. Kevin on Facebook asks, I was terminated due to COVID and was paid severance. My last severance was paid in July 2021, so 2.5 years ago now. I was rehired in August of 2021. My question is, do I start as a new employee for benefits like vacation? I've been working with this company since 2013. Kevin, what an interesting question, and interesting questions are personally my very favorite questions, although oftentimes they're not the easiest or straightforward of questions to answer, but certainly my favorite. So here's the thing, Kevin. It will depend on the term of the contract or the offer letter that you might have signed when you started again in August 2021. So the first thing we should point to is there any written evidence here of a continuation of employment? If in that contract, Kevin, or even in the company's internal system, or intranet, or whatever you want to call it, you are recognized as an employee started in 2013, or if in the employment contract they recognize your service going back that far, or they continue your same vacation entitlements as you previously had, or there's evidence in the contract or in the company's system that you are what would that be, a 10 plus year employee at this point. Well, that's great, right? Ideally, you would want those years of service to count. And if the company has basically put that in writing, either in a contract or in their internal system and software, right, that's great evidence that you're a 10 plus year employee at this point, having started in 2013. Now, there is a counter argument to that, and there's a little bit of a catch to that, I think, and that is the fact that you were paid severance in July of that year. So the fact that you have been paid severance is evidence, Kevin, in and of itself, that your employment effectively ended, right? You were paid an amount of money, which is, severance. It's the amount of money that you're owed as a result of a termination. You got paid severance and then were rehired after that. That might be pretty darn good evidence, Kevin. I hate to say it. Ideally, you are a 10 plus year employee, but that severance payment, right, might be good evidence that your employment formally ended and you started as a day one employee in August. I could tell you that if there's no other written evidence of your employment being continuous, the employer is going to point to that severance payment to say, no, you're not a 10-year employee. You're a 3-year employee because we paid you severance in July of 2021. Right? So that's the one counter argument here to that continuous years of service. My advice would be this, Kevin, give us a call. Let's review your employment contract together. Let's review any other pieces of information or evidence that you might have, right, that might point in one direction or another. And with that information, you'll be better armed to know what your rights are and what protections you might have moving forward. Right? In a lot of cases, right, in the context of a 10-year career, if there's a 1 or 2 month gap in service for an employee, let's say an employee, resigns and then is called back to work, and they're kind of, they're asked back by their last employer. If the gap is only a month or two in a 10-year career, well, then that gap won't matter. You're going to be considered a 10-year employee regardless. But the devil's always in the details, and evidence is extremely important in these kinds of situations. So if there's any evidence in your contract, that's going to matter significantly. But great question, Kevin. Interesting question. Factors on both sides here to consider. Like I said, give us a call. Let's review. I'd be happy to review the employment contract with you and walk you through, a further detailed analysis. All right, next up is Kay. Kay on YouTube asks, I've asked my employer for a pay increase given extra workload due to an acquisition. They denied, as I'm a manager, and said my current pay accounts for this, and that the firm does not pay increases due to increased workload. Great, another great question, Kay. Thank you all, those of you that have asked your questions, because they're always great ones. They're always important. And if I can make a point here, it's really important to ask these questions if you're dealing with a difficult situation at work, because number one, Kay, I'm going to answer your question and I will point you in the right direction here. There are a couple of factors to consider. Secondly, Kay, I can, thank you for your question, because I guarantee you someone else tuning in right now, or maybe even tuning in the future, right, rewatching this live stream, they're going to be dealing with a similar situation. They're going to be dealing with asking for a raise at work in the context of having to do more work and an extra workload. And Kay, by asking your question, you're helping those other people as well, whether you know it or not. So those of you who are asking questions, I mean, that's great. You will get the answers yourselves. You're also doing your fellow employees out there in the world a service as well. So again, much appreciated there. Now, Kay, 2 issues here, 2 points that I want to make. Number one, it does need to be said, any kind of negotiations around pay, right? They are negotiations, which mean that both parties need to agree. As long as an employer is paying above minimum wage, which obviously they are to you if you're a manager, right? Then they can say no, to a pay, to a request for a pay increase. Just like anyone can say no as part of any kind of negotiation, as long as they're operating within the realms of legalities of what the law provides. Right? You need them. You need their consent. You need their agreement to give you a raise. You can have the best argument in the world. You could be the best employee in the company. If they tell you they're not willing to increase your pay, listen, you have two choices. You can either agree to that, right? Or maybe park that conversation for a future performance review, right? Or a future time. Or this is what a lot of employees do, okay? They go out there and find them another employer, another job that will pay them better, right? That is a reality as well. And that's why, the job market is competitive, right? If you're good at what you do and bring a lot of value to your employer, there may be another employer out there that's willing to pay you more. And I'd suggest you perhaps explore those opportunities, right? If your employer is not willing to pay you what you deserve. Now, second part of that analysis here is it's clear by your question that you are being asked to do more in your job because of an acquisition. Now, this raises the possibility and the conversation of a change to your terms of employment. So I can understand that this might be part of an acquisition. Maybe that's a short period of time where you're asked to be doing a ton of work, and things will eventually go back to normal. But Kay, if this becomes a prolonged workload, and if your employer is going to be basically indefinitely expecting more and more of you for the same pay, you start to enter this possibility of this being a constructive dismissal. A constructive dismissal is basically a breach of contract situation where your employer has changed your terms of employment so significantly, it's not the same job at all. It's not what you signed up for. It's not what you agreed to. That might give you the right to either reject that extra workload, to reject that increase in your responsibilities, or if not, you'll have excellent bargaining power to negotiate a severance package, to effectively consider yourself terminated, obtain your severance entitlements, and hopefully get moving on to that other job that's going to pay you better. So my question in response, Kay, would be this. Listen, if this is a significant increase to your workload, if you're having to work 20 hours more a week over and above what you would typically work, and if that is going to be either indefinite or for a prolonged period of time, I can tell you that may very well be a constructive dismissal situation, and it's either going to give you the leverage that you need to, number one, perhaps take a step back and not, and tell your employer you cannot expect that kind of workload from me. I'm not going to do it, and do so in a way that you won't be punished or reprimanded for that, right? Or B, if they're not willing to increase your pay, or they're not, or they're going to tell you, no, you have to do this work. We're not going to allow you to do less. That might be excellent grounds and a great bargaining position from which to be able to negotiate an exit package, get your severance entitlements, and get moving on to a job, where they're going to treat you fairly. Now, before you mention severance to your employer, okay, before you get into that conversation, let's have a chat off air about it, right? Let's make sure that you are placed in a very strong position from a bargaining point of view to be able to make that request. A lot of times these situations are very delicate. You want to tread very carefully, and you need some guidance and some advice. So again, give us a call. We can have a chat about that. All right. Helen, who's a frequent viewer, thanks for tuning in. Helen asks, can I not accept the WCAT decision as I may get more compensation for a wrongful dismissal from a court? Helen, I'm assuming you're referring to workers' compensation or the WSIB in Ontario. I'm not sure what province you're in, but it would be workers' compensation, I believe you're referring to. The short answer, Helen, is probably not, in the sense that WSIB and that particular workers' compensation process. So this is, for all of you tuning in, a process in Ontario whereby if you are injured at work, you might be able to claim compensation as a result of that injury. Again, for injuries that specifically happen in the workplace or as a result of the workplace. Helen, that process you are effectively committed to, if the employer is enrolled in workers' compensation and has that insurance, it is not something you can necessarily opt in or out of. And if you're going to be receiving workers' compensation and effectively insurance from that, it may count against any severance entitlements that you might have that overlap, right? So it's an overlapping period that might be relevant. Yes, our courts in Ontario have ruled that in most cases you cannot receive both workers' compensation and severance for the same time period, and that becomes a bit of a delicate issue, certainly. So, we can have a chat about off there if need be, Helen. But you may be, if you're already involved in that process, you may be stuck with it. All right, we'll speed up the answers here, guys, only because we're starting to run out of time. Laura is up next on Facebook. Laura asks, when do I have to disclose my pregnancy to my current employer versus when starting a new job or interview for a new job? Uh, Good question, Laura. Certainly, when you are interviewing for a new job or starting a new job, there's no real obligation in that context to disclose that you are pregnant. Our courts, our Human Rights Tribunal in Ontario has said that many times over. There's no obligation to disclose that. If you choose to disclose it, that is your right. You are within your rights to do that. But my point is, you don't necessarily have to. And also keep in mind that if an employer decides not to hire you, or certainly if they decide to terminate your employment as a result or because of your pregnancy, well, then, should go without saying, that's discrimination, and that is illegal in Canada. You cannot refuse to hire an employee or terminate an employee because of their pregnancy or because of their gender or because of their race, ethnicity, religion, nationality, disability, of course, as well. That is what we call, and that is discrimination under the law. That is illegal in Canada. Unfortunately, we do see employers making those kinds of decisions. Quite frankly, Laura, if even 1% of the reason for not hiring you, or perhaps in letting an employee go, is related to your pregnancy, or related you having to, telling your employer that you will have to take a maternity leave or a parental leave, and that this can apply for fathers as well. By the way, if you would tell your employer that your wife is giving birth or your partner is giving birth and you're going to have to take some time off as parental leave, that is completely legitimate and legal. If your employer punishes you as a result of that, that would be discrimination under the Human Rights Code, in which case, obviously you'd be owed severance in those circumstances, but you would also be owed additional damages, as we call them, additional compensation for that discrimination, for the reason for termination and the way in which you were treated. All right, Candice on LinkedIn asks, I have great appreciation for this live platform as it serves a valuable resource. Today I logged on to observe, but I will be spreading the word about this fantastic initiative. Candice, I thought you were going to ask a question, but I do very much appreciate the kind words. Thank you very much for tuning in. And yes, please feel free to share this with your colleagues and friends. We're here to provide information and to inform people as to what their rights are in the workplace. All right, Kathy on Facebook here, and perhaps we'll make this the last question for the day. Can an employer terminate you, or can they end your extended benefits while you're in litigation against a disability claim denial with your company's insurance provider? Very good question, Kathy. Your employer can terminate your employment. It is a very specific situation, Kathy, that is called a frustration of contract. This, interestingly enough, can actually strengthen your disability insurance claim, because really the only way in which an employer can terminate an employee who is on a medical leave of absence is if, again, it is a frustration of contract situation. That's the phrase, frustration of contract, Kathy. That's the term that is used. And what that means is that your employer is basically taking the position that because of your disability, you will not be able to return to work again. Effectively, they're taking the position that you're permanently disabled. If that's the case, Kathy, there should be no question, right, that the insurance company should be paying you disability benefits. So it is actually, again, it potentially strengthens your argument. If the employer is taking the position that you'll never be able to return to work again, clearly they're making that decision, or at least they should be making that decision on some degree of medical evidence. So what that likely means is you probably have evidence from your doctor saying that you'll never be able to work again, or at least the prospect of you returning to work in the future is slim, is not possible, not likely. And so if that is the case, Kathy, perhaps unfortunately, yes, your employer is allowed to let you go. By the way, you would be owed some degree of severance in a frustration of contract situation. It's not your full severance entitlements as an employee, but it would be some amount of severance. Yes, they would be able to also stop your benefits coverage during that period of time. That's something that can be dealt with, by the way, through the disability insurance claim as well. Helen or Kathy, excuse me. But that's the situation you likely find yourself in. Hopefully, you're dealing with the litigation in terms of the insurance, and a resolution in that respect is on the horizon. And certainly to deal with a termination of your employment, before you say anything to your employer, before you make any decisions, please give us a call. Hopefully, we're handling your disability insurance claim, by the way. And if you are, you can certainly speak to one of our employment lawyers as well. Right? But if another law firm is handling your disability insurance claim, please give us a call on the employment matter. Happy to walk you through that situation myself, review the documentation with you, and tell you what your employer should and shouldn't be doing with respect to that termination. If there's a chance you might be able to return to work, Kathy, and they've terminated you, well, that might be illegal. That might be discrimination, or you might be owed your full severance entitlements. Although, again, it's a very delicate situation. We will leave it at that, folks. We've gone over time a little bit here. Thank you all so much for tuning in. Once again, my name is Alex Lucifero, partner and employment lawyer at Samfiru Tumarkin, LLP. This has been I guess, Thursday edition of our live Q&A. Tune in next time. If we didn't get to your question, or you didn't have a chance to ask your question, we do these regularly. One will be coming up tomorrow at 1:30 Eastern time with my colleague Dan. Tune in then. Until next time, everyone, have yourselves a great rest of the work week. Take care.